It's 1:45. It seems like a good time to pause for a moment, let you digest some of these thoughts you've been carrying, as well as the pizza. If anybody has any questions for our panelists, now's the time to raise your hands and jump on in. Please. And speak loudly so the mic can get you as well.
I'm Sam Houston Allred, so named because I was born in the Sam Houston bed at the governor's mansion in Austin, Texas, during my father's second term as a Roosevelt New Deal progressive Democrat governor of Texas. He had been twice Attorney General of Texas and filed and won for the people of Texas more antitrust lawsuits against corporate monopolies than any Attorney General in the history of the state from 1931 to 35. He did that, of course, at the height of people's awareness, and he was successful because people in Texas at that point were aware of the corporate monopoly causes of the Depression. Okay, my question is, you mentioned Hudson v. Michigan and the judicial statement availability of civil damage remedies. My question is this: the extent to which time passage is a factor in controlling liability for crime and civil damages, and to what extent you think the current Supreme Court, particularly dominated by the Bush crime family, will rule on those issues?
Well, on the civil damages question, which is, right, the theory that Vic was talking about is, well, if the police burst into your house in violation of the Fourth Amendment, yes, they could use whatever they found in there against you, but you could sue the police officers for violating your Fourth Amendment rights, and this prospect of being sued will be sufficient to deter the police from violating your constitutional rights.
And to compensate for the interest that was violated.
This Supreme Court has, and I imagine the next one, the Roberts Court, because I'm talking now about the Rehnquist Court, have done as much as they can to strip away the ability to bring Section 1983 damages actions as it's possible to do without just repealing Section 1983. So if the police officer acted reasonably under the circumstances, and a police officer can be reasonable in acting unreasonably, the Supreme Court has said, yes, it's true they used excessive force here, or yes, it's true this search violated the Fourth Amendment, but the officer was acting under a lot of pressure, and maybe he didn't understand the facts quite the way that they turned out to be, and therefore, no damages at all. And this is also a Supreme Court that has restricted attorney's fees in these cases, making it hard to find lawyers to bring them. And it's a Supreme Court that has held that you can't bring a class action. So if you have police officers continually violating people's rights by conducting illegal searches, you can't bring a lawsuit, even a class action, unless you can show it's likely you personally are going to have them violate your rights again. So that in the Los Angeles against Lyons case, you had a police department in Los Angeles was out of control, chokeholding black motorists. They would pull people over for a traffic violation, they'd chokehold them, and they would die. In part because the police, you're not supposed to do a chokehold at all, and in part because they weren't trained to do the chokeholds correctly, and in part because the then chief of the Los Angeles police was a racist who claimed that black people had different tracheas, and that was why black motorists were dying when they were being choked off, and they didn't why they wouldn't have died, right? So the Supreme Court said, when a guy who was chokehold brought a lawsuit saying, we want an injunction telling the Los Angeles Police Department to stop doing these kinds of chokeholds, the Supreme Court said, you don't have standing, because you can sue for the damages of the chokehold you already had, but you can't show you personally are going to be chokehold again. And since you can't show that and no one else can, no class action for injunctive relief. So this idea that civil lawsuits are going to stop police misbehavior, well, if you change what civil lawsuits look like, it might. But under the current rules, there's going to be massive under-deterrence. However, one of the other things we know about civil damages lawsuits is if you bring a Fourth Amendment lawsuit, you better hope they didn't find anything in your house. Because just imagine what the lawsuit looks like when they get up to cross-examine you and they begin by saying, Mr. Amar, I noticed you're wearing a striped outfit today. Could you explain, what's your current home address? It's not the same as the home address of the house that was illegally searched. That's an odd number. Can you explain that? It says no damages at all for the jury. So this is not a court that's really into the idea of having damages lawsuits by private individuals as a form of regulatory or social control in the way that antitrust suits used to be.
In the case of the court taking it away with one hand, what it was removing with the other.
That's right. Pay no attention to my hand. Right? You know, somewhere under one of these things is your ability to vindicate constitutional rights.
Another question. Yes.
How went to the idea of, unrestrained executive power are Roberts and Alito and company going to be when there's a Democrat in office?
That's a good question. I mean, I will say this. I mean, that's a separation of powers question. I will say this about federalism, which is the other of the two big structural themes. To their credit, at least 3 of the conservatives on the Supreme Court followed their federalism instinct, and tried to rein in Congress's ability to regulate marijuana in the medicinal marijuana case in California. Justice O'Connor's dissent, didn't kind of flip sides because the war on drugs was involved. She said, "Look, I wouldn't legalize marijuana, but I think the state of California has the right to do that, and Congress has no business regulating this because it's outside Congress's Commerce Clause power." So I don't know whether there will be consistency in separation of powers down the road, but I think conservatives and Republicans think structurally they're going to win the White House more often than they're going to lose it. So if they have a long-term perspective, they'd rather live with broad executive power as a general matter.
Well, you got to remember also that the thing on the other side is often going to be individual rights. And if you are hostile to individual rights on a whole lot of issues, then the fact that you're aggrandizing executive power may not bother you, even if the power you are aggrandizing in a particular case. Right.
No,
go ahead.
So the conservatives, they didn't find broad executive power when Bill Clinton asserted what I thought was a very strong case for temporary immunity when he was sued by Paula Jones. So I do think there is some kind of partisan backdrop that informs some of this stuff, but I just don't know how.
Well, and you're going to start seeing in the federalism area the conservatives being put to the test, because what has gone up to the Supreme Court in recent years is what I think of as red state federalism, right? Which is the state of Alabama saying we can't be sued for violating the employment rights of a nurse who works for the University of Alabama system, or Tennessee saying you can't sue us for violating the rights of a disabled litigant, and like. But what's going to happen when we start seeing a lot of blue states up there saying, well, we think we have the ability to regulate socially in these ways. We saw, a lot of people who were really for federalism did get off the bus, even in the medical marijuana. Affirmative action. When a state says, we really think that this is the best way of ensuring equality, to have race-conscious affirmative action in our state university, the conservatives got off the bus, got off the bus on that. So there are a lot of issues as you start seeing liberals focusing on the state level and trying to make changes at the state level that they can't get Congress to make. There's going to be a lot of friction, and it will be very interesting to see whether blue states get the same deference from the Supreme Court that red states get.
One area where there was a political backdrop, but ultimately doctrinal consistency held the day is the First Amendment. I mean, the people on the court who are strong First Amendment advocates, and they include some conservatives like Scalia and Kennedy, they're as likely to deploy the First Amendment to protect very radical leftist causes as well as kind of more corporate or more Boy Scouty right-wing groups.
Any other questions? Yes, in the back.